Ripple scores a significant victory against the SEC after the judge rules in their favor. Will they be able to take advantage of this and force the SEC to backtrack? Is Ripple's position in the lawsuit strengthened as a result of the ruling? Stay tuned till the end of the video to find out. But first, we are giving away 50 XRP coins at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome back XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribing to this channel to stay updated at all times. The Securities and Exchange Commission filed a lawsuit against Ripple and members of its leadership at the end of 2020, alleging that the company sold and continues to sell the XRP cryptocurrency in violation of federal securities law. A prolonged back and forth has occurred between the SEC and Ripple about the kind of information that must be made accessible through the discovery process. Ripple has requested various papers outlining internal SEC interactions and regulations. Do you recall the Hinman speech on Ether that took place in 2018? Hinman said, "Not a security." It is also worth recalling that in a speech given in 2018, William Hinman, a former director of the Securities and Exchange Commission who is also known for his controversial remarks, said that Ethereum cannot be deemed a security since it is not highly centralized. In this particular instance, the Ripple Corporation contends that XRP is not a security in the same way that Ethereum is. However, according to the Securities and Exchange Commission, Hinman remarks that day was his personal viewpoint and did not represent the institution. He received millions of dollars in compensation from the business throughout his time at the SEC, including during the time he prepared and made those statements, after which he announced that offers and sales of Ether are not securities transactions. It is his responsibility to explain why it was not a blatant conflict of interest, which must be done under oath. Several pieces of recorded evidence indicate that Hinman's own financial interests were obviously tied to the speech he delivered. Hinman said in his speech, "And taking aside the fundraising that followed the birth of Ether, based on my understanding of the current status of Ether, the Ethereum network, and its decentralized structure, current offers and sales of Ether are not securities transactions." The judge agreed since it did not come within the purview of the privacy statute, according to the judge. This was precisely the reason why Judge Ned Byrne authorized access to the emails in this case. Because Ned Byrne has previously denied several of Ripple requests as a result of the SEC assertion of its rights of privacy and privilege, this was a new request. Generally speaking, governmental institutions in the United States have the power to withhold some papers from a court on the grounds of internal secrecy, as is well known. As a result, several files were not given to the case. Hinman's personal beliefs were expressed in the Ethereum speech, according to Ned Byrne, who made the decision to provide Ripple access to the speech supporting documents. Judge Ned Byrne said that, although Hinman and the SEC concede that agency personnel discussed his speech, it seems that it was just ancillary to meaningful policymaking, and not an essential link in the SEC deliberative process involving Ether. Consequently, communications concerning the speech or drafting versions of the address are not protected as pre- or post-decisional or deliberative agency documents. Judge Sarah Ned Byrne formal judgment, which was sent to the parties, entails this statement. While Hinman and the SEC have determined that the staff of the institution is participating in some talks concerning the dialogue, the conversation has not had a direct influence on the SEC determination on Ethereum. As a result, emails or other draft texts related to the speech are not included in the group of materials that the institution is attempting to secure. Ned Byrne further orders SEC to review its privilege log and produce, in full or in part, any documents previously withheld. Because of the Ned Byrne decision, Ripple now has more ammunition to use in its legal defense as well as in the court of public opinion. Many people, particularly those in the cryptocurrency industry, believe that the SEC has been too harsh on the cryptocurrency company. In reality, even though Ripple was victorious in this case, the company was continuously implying that Hinman remarks were equally binding on the Securities and Exchange Commission. Judge Ned Byrne put an end to this controversy by ruling that this was not the case and that Hinman's statement solely bound him. What are your thoughts on whether or not Judge Ned Byrne is correct? Tell us about it in the comments section. Ned Byrne, on the other hand, upheld the SEC motion to deny the Ripple team access to a slew of additional papers that the Ripple team had sought. To which Jeremy Hogan said on Twitter, "The performance of Ripple was much below my expectations." Interestingly, the judge seems to have required very little to link a document to a deliberation, and has determined that Hinman's statement was only his own opinion. Ripple, on the other hand, receives the emails discussing Hinman's speech. The final score is SEC 2 and Ripple 1. Ripple, for example, failed in its attempt to persuade a judge to award it access to conversations between the then SEC crypto head Valerie Szczepanik and a Treasury Department official, as well as a presentation made by Szczepanik to Michael Pivowar, the former SEC commissioner. Overall, Ripple sought access to 14 entries and 3 additional documents. Will this oversight come back to haunt Ripple in the next hearing? Please share your opinions about it with the rest of the community in the comments section. A Ripple executive legal counsel, Stuart Alderoty, also took aim at the Securities and Exchange Commission on Twitter, accusing the agency of attempting to prolong the trial. Ripple is hoping for a swift settlement, while Alderoty claims that the SEC is attempting to prolong the matter as long as it possibly can. In response to a speech by the current SEC Director Gary Gensler, the lawyer said that the SEC was playing the delay card and exploiting it to their advantage. He accused the SEC of employing regulation by enforcement to create an unequal playing field, and of picking winners and losers according to obscure rules they make up as they go along. Stuart Alderoty in his thread of tweets said that, because after all, that's why the SEC plays the delay card and uses it to their advantage. So much for justice delayed is justice denied. How about publicly committing to moving the Ripple case as swiftly as possible with no more delays? His speech says, a high-impact case pulls many other actors back from the line. Does that sound like regulation by enforcement to anyone else? The SEC intends that the mere filing of a case chills behavior, regardless of whether they are right on the law or the facts. As part of their frantic attempt to keep Hinman from being deposed, the SEC said that Hinman did not have unique first-hand knowledge of what was going on in the cryptocurrency market. This is ludicrous. Hinman's important role in providing Ethereum with rocket fuel for its token flight to the moon is best captured by these chosen facts alone, which get to the core of the matter. He and/or the SEC may have informed an exchange about his Ethereum speech in advance, while the rest of the market remained in the dark about it. As a result, both Hinman and the SEC want everyone to assume that the Ethereum speech should never have been construed as policy or as any type of notice regarding Ethereum classification, just as the SEC contended in the Ripple case in December 2020 that we were all supposed to have known XRP was a security since 2013. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.